Good afternoon. Welcome to the Appellate Division First Department. According to this, we have over 6 hours of oral argument time. Not happening. So please make sure that you request the time that you actually need. Keep in mind that we have read over your briefs. We are aware of your arguments. And so we know what the relevant issues are. Also, keep in mind that the clock is for you and not for us, so that if we have additional questions of you, we will certainly go beyond, okay? People v. Martha Arroyo. 5-1 and 5. Camacho versus Pintaro. 2 minutes? Excellent. Do we have a respondent? Oh, perfect. 2 minutes. Matter of Zuri, submitted. Buckley versus Nicholas.
Defendant's appellant, 5 minutes, 1 minute rebuttal. Respondent, 5 minutes.
5-1 and 5. Appleyard versus Tiggs.
Defendant appellant Tiggs, 4 and 1 yard. Appellant Orthopedic Associates, 7 and 3.
Respondent, 5.
4 and 1, 5 and 5. Rusiski versus Kraus Management. I'm sorry, I couldn't hear you. 5-1 and 5. People versus Reginald Urban. Submitted. I'm going to apologize in advance for mispronouncing this name. Scarola Zapavo versus Dynamic Credit. 5-1 and 5. 885 3rd Avenue versus Alden Global. 6-2 and 6. People versus Ashley Williams. 5-1 and 5. Fundo. Okay, that's all I'm going to say. You know who you are. 6-2 and 5. Justice Friedman, by the way, is recused on that matter. Lee Ta Enterprises versus Dagon. 3. 4. You don't have a cross claim? You do? No? Okay, 4 and 3. Aguilera versus BJ's Wholesale. Matter is submitted. People versus Jason Alvarez. Matter is submitted. Zeal versus Zoo. For Hugh. 5 and 2 and 5. Tate versus Ream Plumbing. 3-1 and 3. Burlington Insurance versus New York Construction. 5-1 and 5. Legal versus Sarwell is submitted. First matter up for argument is People versus Martha Arroyo. Whenever you're ready, counsel.
Stephen Chu, on behalf of Martha Arroyo, may it please the court. Ms. Arroyo's case is unique for 3 reasons. The first is that she has multiple comorbidities.
Yes, and so I wanted to ask you about that, counsel. Is there anything in the record which establishes those comorbidities? You talk about obesity, you talk about I think you said COPD, I might be confusing you with another case. You talk about hypertension, you talk about the fact that she is a breast cancer survivor. Any of that in the record?
Yes, this is in the record. It's before Justice Richter. The order for stay is actually submitted in the Court of the Record on Appeal, and these are in the briefs that were presented to Justice
No,
Richter.
I'm saying, any evidence? Is there any medical record supporting any of that?
Yes, the doc's comprehensive medical summary was presented to Justice Richter. In fact, Justice Richter did not grant stay until she got documentation from docs that verifies this. She was not willing to grant a stay just on our say-so. And the three specific comorbidities are, and as Your Honor listed, there are many, but three in particular are HIV positive and that she's a cancer survivor, both of which affect her immune system and make her immunocompromised. And then COPD is a chronic disease that does cumulative and permanent damage to her lungs.
Were these conditions, were they present at the time that she took the initial plea back in, is that 2019?
We believe so, but they weren't presented to the sentencing judge because COVID obviously had not happened yet.
Well, but would you not have presented to the sentencing judge anyhow in terms of attempting to receive a lesser sentence?
It was a negotiated plea, which is why this is a particularly unique situation, and that's the second issue why this is unique.
So she was sentenced on the sale of a controlled substance in the second degree, which was selling narcotics out of her apartment on the Lower East Side. She was sentenced to 3 years incarceration and 5 years post-release supervision. Is that correct?
That's correct.
And now you want a decrease in sentence. Actually, you want time served.
She has served 18 months on this sentence, and we believe the Eighth Amendment in this particular case requires a consideration by this court of a lower sentence because her continued incarceration is disproportionate.
How do you respond to the people's argument that you're asking for a reduction based upon cruel and unusual punishment? The people, I believe in their papers, argue that in order to make that argument has to be made before the sentencing court or the trial court.
Yeah, that argument from the people is incorrect. This court has done it for three reasons it's incorrect. This court has done it repeatedly, especially during the Rockefeller drug laws era, where this court specifically relied not on excessive sentence, but on the Eighth Amendment, on the constitutional right against cruel and unusual punishment to reduce it below the statutory minimum.
Right, I saw that. I mean, but as you just said, that was in reference to the Rockefeller drug laws, and there was numerous articles, publications, et cetera, concerning the harsh impact of those laws. The one case I think that you cited, I believe, was Martinez, which I thought did not deal specifically with the Rockefeller drug laws, where we did reduce it, but I didn't. How does that correspond to the facts here?
That's exactly right. So Martinez was not a Rockefeller drug law. It was a drug conviction, which is what we have today. It cites People versus Skeffrey, which is a Rockefeller drug law, and Skeffrey also cites People versus Andrews. Those are cases, that's the line of cases that allows this court to do it. And the reason this court should do it is because of the standards listed in those cases. It says you look at the lack of criminal record, you look at the defendant's age, you look at poor health, you look at family circumstances. That's all existing here. To Your Honor's point, this was a case where all the charges really were less than 1/2 ounce. They would all be third degree or less charges. The minimum sentence would be 1 year, which she has already done 18 months. The only reason this case is still active is because in one situation, the police exercised a controlled buy of 61 grams. But Ms. Arroyo has a lifetime of trauma and drug addiction. This is her first-time felony, and under Brody, under this court's constitutional duty to address whether this legal sentence is still cruel and unusual, this court must look at evolving standards of decency. Is it too much of a risk, given her specific comorbidities, given the evidence in the record presented to Justice Richter, given the repeated hospitalization that she's gone through over the last 2 years, which we've continued to update this court about, whether this is the rare case that requires an Eighth Amendment or Article 1, Section 5 intervention by this court? If there are no further questions, I'll cede my time for rebuttal.
Good afternoon, Your Honors. Carl Dubel for the people. May it please the court. First of all, defendant's claim is waived here. She signed a valid waiver of the right to appeal. Second of all, her Eighth Amendment claim, as Your Honors has mentioned, was never raised before the trial court. So for that reason, it's also unpreserved. Now, the standard for an Eighth Amendment claim on direct appeal is whether the sentence was grossly disproportionate to the conduct. Defendant here was charged with the highest level of drug sale crime possible in the state.
She received the minimum sentence, is that correct?
She received not just the minimum sentence, Your Honor. She received the minimum sentence on a reduced crime, not even the crime that she was charged with. Yet all her arguments are about her medical conditions and the risk of contracting COVID in prison and how that is unconstitutionally high. That is not a proportionality claim that can be raised on direct appeal. That has nothing to do with her conduct or the length of her sentence.
But we could reduce the sentence in the interest of justice, could we not?
As far as you could reach the Eighth Amendment claim on the interest of justice, but I don't believe this court has the ability to find that her sentence is excessive in the interest of justice because she received a minimum sentence. The statute that in the CPL that provides for excessive sentence interest of justice relief says that this court has to impose a legal sentence. If she already received the minimum, it can't go any lower without being an illegal sentence. Now, her claims regarding her medical conditions are really conditions of confinement or deliberate indifference claims. Those are not really criminal claims. Those are civil claims.
Well, I know in your papers you talk about the fact that she could ask for a compassionate release from on parole from the Department of Corrections, that she could bring forth an Article 78 against the Department of Corrections as well.
Yes, Your Honor, and I actually believe if we're looking at other avenues that the defendant could pursue, I believe medical parole would be the perfect choice. She would be able to be evaluated by a doctor, all her medical conditions could be properly laid out.
Why should we even go to that? Why should we even get there? I mean, if we're empowered to reduce her sentence, why not simply reduce her sentence as opposed to having her incarcerated and then running the risk of possibly contracting COVID? I noted also in your papers, you talked about the fact that there was no mention of whether she had taken the vaccine, whether she was vaccinated, whether she was not vaccinated, or anything of that nature.
Yes, Your Honor. Why we believe medical parole, as opposed to just this court reducing her sentence, is proper is because the record is severely lacking in a lot of different places. There isn't a full record of her medical conditions. We have no idea whether she's vaccinated or not. And most importantly, on the other half of that analysis is we have no idea the conditions in which she would be confined in. We don't know which correctional facility she's going to go to. We have no idea what DOTS is doing or could do to lower her risk of contacting COVID. And that's why we think on this record, which is, from a 2019 conviction that was before COVID even happened, why we think it's inappropriate to reduce her sentence in this proceeding. Unless you're...
I'm sorry.
Yes.
The nature, the conditions for her being released, was she the equivalent of house arrest with a bracelet where she couldn't really, almost a kind of virtual prison, although she was within her, outside the prison system?
I don't believe so, Your Honor. I think the order from this court, it released her to a housing facility, and it placed her on supervised release, but I don't think it was any sort of house arrest or anything like that.
Does she have to now serve the remaining 18 months of her sentence in jail?
I believe my opposing counsel touched on this in his brief. I don't know what the exact amount of time left, but I think it would be around a year would be how much she would have to serve, considering good time credit and those other things that would allow her to be released. But as I mentioned, Your Honor, she could have applied for medical parole 2 years ago that would have allowed her to be released immediately. She can also, I don't believe there's anything preventing her from applying for that tomorrow. And unless Your Honors have any questions, we'd ask that you affirm.
Thank you.
Thank you.
Yes, Justice Mendez, she does have to go back and serve 18 months, and that's why we're here today. We've been complying with the stay order, which has sent her to programming with housing by Osborne Association, but the stay order told us to file this appeal forthwith, and that's what we've done. We provided 60-day updates with updates on her health condition. She has been hospitalized again. She's actually in the hospital today. She has been vaccinated. I understand that's not part of the record, but the reasons that are in the record, her health comorbidities, do reflect a need for this court to exercise its interest of justice jurisdiction on the Eighth Amendment claim. The state's response on the statute is wrong, and we've said that in the reply brief, and I urge you to look at it. But at the end of the day, this is a question within this court's power, and whether she belongs back in prison is a question of your discretion. There are no jurisdictional limits. There are no procedural hurdles. The waiver is bad. In 1962, the Supreme Court said in Robinson versus California that criminalizing drug addiction violates the Eighth Amendment. We're here 60 days later, and we're asking the same question. Ms. Arroyo doesn't battle just addiction, but she battles a whole host of permanent, debilitating diseases. The question is whether this is cruel, and the question is whether her continued incarceration comports with standards of decency and fairness. We urge this court to reduce her sentence.
Thank you, counsel. Thank you both. Camacho versus Pintaro.
Good afternoon, Your Honors. The reason I asked for 2 minutes is because I left two things out of my reply brief.
Who are you?
Oh, I'm sorry. Peter Taglia, I'm arguing alone, so I didn't introduce myself.
Thank you.
Peter Taglia for the appellant, Dr. Pintoro. And when it comes to Fry, and you always have the issue, methodology versus conclusion. You can't challenge the conclusion, you'll only challenge the methodology. And then I came across a case preparing for argument, Marceau versus Novak, 2007, where this court said, we reject the argument, ignore the conclusion, accept the methodology. So that's one reason I argued. I wanted to bring that case to the court's attention, which I sent in Friday. And the second is, when you talk about Fry methodology, and you have, in a drug case, be it Viagra, the Tylenol case, or this case, it's not like other cases where you try to make a deduction. You have 75 years of this drug being on the market. And what I also left out of my brief, they couldn't even find one case report. Okay, how come they didn't go to a sister drug like they did in some of the cases? If they couldn't find Zocor, they went to Crestor. No, there's plenty of immunosuppressants on the market. They never caused this condition. And when we talk about methodology, the methodology in this case was anti-Fry, because the expert said, I could find no evidence, 4 times, I could find no evidence that it can't cause a neuropathy. And the Ratner case, the Second Department case, uses the term extrapolation. The extrapolation in this case was 4 times worse than Ratner. It extrapolated from low dose to high dose. From
But
oral,
counsel, she took less, the dosage that she took was far, far less than what was prescribed. She only took it once,
right, that's what I'm
and
saying.
that was it.
That's my point. I represent the doctor who prescribed the medicine.
Right, no, I understand, that was a
Okay.
kind
It
of.
also, they extrapolate to IV, oral use, and then they throw around neuropathy, like it means everything. Everyone knows cancer patients get numbness in their fingers. They don't get foot drops. So for all of those reasons, I thank you for listening to me, for those additional arguments that I didn't think of the first time.
Thank you. Buckley versus Nicholas?
Good morning, Your Honors, or good afternoon, my apologies. Jeffrey Bowser from Menicucci Villa Chilme on behalf of the defendant appellants Michael Nicholas, 2112 MB LLC, and Vertical Professional Solutions LLC. May it please the court. This case is relatively simple. During the COVID tolling from the executive orders from the governor, the court granted default judgment against our clients. Their time to oppose had not come yet because the time to oppose had been told, and therefore, at the time the default judgment was granted, they were not in default. Therefore, it exceeded the court's authority and should be vacated.
What justifies awarding legal fees as summary judgment in lieu of complaint? Drill, you have no idea how much the legal fees are until you have a hearing and go through all of the circumstances of the representation. How does that fall within summary judgment in lieu of complaint?
It doesn't. I'm on behalf of the defendant appellants. The fact that an attorney's fee conference was required is all the evidence we need that this was not a document for the payment of money, an instrument for the payment of money only. But before we even get to the question of whether or not we have a reasonable excuse and a meritorious defense, The court did not have the power to grant a default judgment at the time it granted a default judgment because our time to answer had not yet passed. It was told by the executive order. If you
Well,
look-
my understanding, without going to each particular executive order, we do know that by June 2020, papers were permitted to be filed.
Yes.
And you were clearly served well before
Yes.
COVID. I don't even think we really need to address the service issues.
No, I agree. The service,
So the sole issue is how can you explain your first response in 7 months after the entry of the judgment in December of 2020, after you ignored the notice for the hearing on fees and all those little steps, and clearly you had a full and fair opportunity to put in papers in June. That's why the lower court kicked it from May when it really started opening up a little bit. I'm being colloquial, but you understand what I'm saying.
Right.
So where is this toll that suggests that you were timely?
So there's two aspects of that. The first argument that I would make is that under, and I recognize it's the second department, not the first department, but if you look at the language in Brass v. Richards, which is 195 AD 3D 582, it's cited in our brief, they specifically hold that the time to respond was told for that period, meaning at the time the default judgment was granted, it doesn't matter that we could have answered. It matters whether or not we were actually in default at that time. If it was a toll, if the first department agrees with the second department that the executive orders told our time to respond, then at the time the default judgment was granted, we weren't in default. And so just without questioning whether or not we have a meritorious defense or a reasonable excuse, that becomes a threshold issue on whether or not the judgment, which is based on that default judgment that was granted during the pendency of those executive orders, which didn't expire until November of 2020, whether or not that default judgment exceeded the power of the court. We argue that it did, and therefore whether or not we have a reasonable excuse or meritorious defense doesn't matter. Their reply, or their opposition, talks about when we could have responded, which is what Your Honor just brought up, is that we could have responded starting in about June. That is it's a red herring. The fact that we could have responded isn't the important, it doesn't matter to whether or not the court had the power. Then the second thing is, okay, if you disagree with me, if you disagree with the position that it was a tolling and therefore the judgment, or the default judgment exceeded the court's authority, you still have to look on whether or not we have a meritorious defense. Our argument, and the argument that is supported in Addison Plumbing, which I recognize is a Supreme Court case, but the judge there does a good analysis of this, is that even if you were to set aside, even if you were to ignore the tolling aspect of the order and the publication thereof had a large effect on people's understanding of what their obligations to court were. As the as the appellate term found in Winston Penelos v. Seaview Manor, these executive orders effectively led to a timeout in litigation in the courts and in society generally. That's a quote from that case. So our client, and he put this in his affidavit, he stopped coming to New York. He lived in Florida. He wasn't checking on his businesses. He wasn't closely following what was going on in the litigation. And you have to remember, at the same time as this was filed, there were multiple other litigations that involved these two parties. And so just because he was served, especially since it wasn't a...
No, counsel, I'm sorry. You started talking about the meritorious defense.
Yes.
What would the meritorious defense be?
So the meritorious defense, the primary meritorious defense is this is not an instrument for the payment of money.
Right.
And therefore, we should have
And why would it not be an instrument for the payment of money?
Because it included terms in addition to just the payment. In addition to this payment, it included confession and judgment, it included releases, it included the obligation to negotiate, I believe, a license agreement. It included...
But it also was an obligation to pay plaintiff money.
Yes, it was, but the case law on this is very clear, that in order to use summary judgment in lieu, you have to just be a payment instrument for the payment of money only. And even if it converts to that after some time, which you could argue in this case it did once the additional documents were agreed to and signed, it's still an instrument for the payment of money which you can't use for summary judgment. In addition to that, although courts have found that attorney's fees can be part of an instrument for the payment of money. They've only done so where the attorney's fees were for that specific action. In this case, the attorney's fees at issue relate to 2 other actions that were ongoing at the same time, and which an inquest had to be held. Finally, I do want to come back on the defenses.
Yes, you can do that on rebuttal.
All right, thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. For the respondents, Rosenberg, Fortuna, and Laitman by Joseph P. Sacco.
So counsel, if we could just work backwards, if you could just address the issue as to the meritorious defense.
Sure, Your Honor. It's respectfully submitted that there is no meritorious defense here. The stipulation settlement is an instrument for the payment of money only, and it's also apparent that the defendant...
How do the attorney's fees become summary judgment in lieu of complaint?
Well, Your Honor, if you look at the stipulation of settlement as the instrument, there's 2 affirmative obligations under the entire instrument. It's the payment of the settlement sum and the provision of a legal defense. So, in effect, that's the payment of legal fees, which was breached under that agreement. It's not uncommon to have summary judgment on the issue of liability and an inquest thereafter to assess what the actual damages are, and that's what that would be under this particular instrument. With respect to the toll, it's respectfully submitted that the defendants were free to go ahead and submit opposition as early as May 4th, if not May 25th, in accordance with the 2 administrative orders that were issued post the executive order. And indeed, they were served, service was complete on all the defendants by February 18th. So it's still, I haven't heard an explanation both in this court today and in the briefs.
On what date did they default?
They defaulted, well, to take it slowly, because I get there was that executive order and the pandemic, they would have defaulted on March 24th, because the original return date of the 3230...
What's the date of the executive order?
The executive order was March 20th. But then the matter was administratively adjourned to June.
It sounded like his central point on this is that on March 24th, they didn't know an answer because of the executive order. So you can't have a default based upon their failure to do that which they weren't obligated to do. I understand that they let a lot of time go with ignoring this, and this certainly is putting aside whether there's a legal default or was an actual default. But what is your response to that legal argument that he makes?
My response, Your Honor, is I would submit that the court administratively adjourned the motion to June. And that adjournment was almost congruent to the time that had elapsed from the original return date of March 31st. So that their new time to respond would have been 7 days before the June date. And they had ample time to do that, because if you track it back to the administrative orders, they could have filed it on May 4th. They could have opposed it even on May 25th, which was well in advance of the new return date of the motion. So, in sum, Your Honor, if there's no further questions, I see the rest of my time.
Thank you.
Thank you, Your Honors.
Counsel, I have a question
Yes.
for you. So let's assume we accept your argument, right, that it was told until the 3rd of November, you know.
Yeah.
So what, if any, explanation did you provide regarding your failure? Because I don't think you responded or even submitted any opposition after the tolling period expired. So can you address that?
Yes, Your Honor. So as my client stated in his affidavit, he was unaware of the action. As the affidavit of the Florida service wasn't filed at the time he wrote the affidavit, so he was not aware that there was a claim that they had served him in Florida. So he didn't specifically put in his affidavit, even though they claimed to serve me in Florida, I was unaware. If you look at the service in Florida, it was served by mail-in mail. And as I was saying just before I got off before, there were multiple other actions between these parties, and this isn't an attorney. So he sees something that includes all of the same parties as another litigation that's ongoing that he's already represented in. I'm not sure it would have triggered to him that this was a new action.
But it was New York, right? The workplace. He didn't deny working there. Am I correct about that? No, that's a yes or no. Which one is it?
Your Honor, there were times that he did work in that building. He had no.
So I take that as a yes. Okay.
Yes, but he had no coworkers there. He could not have had a coworker serve.
All right. So let's go to Florida because
Yes.
there were several attempts, and of course, when it's unsuccessful, you do nail and mail.
Yes.
So, but that was the address, correct?
Yes.
The Florida address.
Yes.
Okay.
Your Honor, in terms of the reasonable excuse, if you take, even if you first of all, I do want to mention the default thing real quickly. When he said they
Well,
defaulted in
counsel,
June.
actually, your time is up, but thank
you,
you
Your
so much. Take care now. Thank you both. Appleyard versus Tiggs.
May it please the court, I'm Barbara Goldberg. I represent defendant appellant Dr. Tiggs. It's our position that the Supreme Court erred as a matter of law in holding that Dr. Tiggs was vicariously liable for the negligence, allegedly, of P.A. Caputo. It's undisputed that Dr. Tiggs did not see or treat the patient during this admission. He was not contacted regarding her, and he did not learn of her admission to Vassar Brothers Hospital until after the fact. In addition, there is no indication in the record that he reviewed or co-signed any of P.A. Caputo's notes. The regulation and the statutes that are cited by the plaintiff do not support the imposition of vicarious liability under these circumstances. The regulation 10 NYCRR section 94.2 and education law 6542 both refer to quote-unquote supervision of a physician's assistant, which has to be continuous, even though the physician doesn't necessarily have to be in the same location as the physician assistant. More importantly, Business Corporation Law Section 1505 Subdivision A, which is applicable here because Orthopedic Associates of Dutchess County is a professional service corporation, requires direct supervision and control before vicarious liability may be imposed on the shareholder of a professional service corporation for the alleged negligence of an employee or other subordinate. And this was specifically noted in the moving papers in the Supreme Court. Here, given Dr. Tiggs's complete lack of involvement in this patient's treatment during her admission, there is absolutely no basis for finding supervision, let alone direct supervision and control.
Wasn't Dr. Tiggs listed as the admitting physician for this patient?
Yes, that's correct, Your Honor, but Dr. Tiggs gave an explanation for that. He said that his name on the addressograph stamp was a quote-unquote moniker used just for administrative purposes. That's at page 70 to 71 of the record. And significantly, even plaintiff's expert Dr. Gallagher admitted that the plaintiff was a patient of the group and the practice served as her attending physician. We don't know from the record how Dr. Tiggs's name came to be on the addressograph stamp. The plaintiff may have said that she had surgery with him a couple of weeks previously, so it appears that a hospital employee put his name on the addressograph stamp.
Who was P.A. Caputo working under?
P.A. Caputo was working for the group, but he did not work specifically with Dr. Tiggs during this admission. There was no indication that he ever contacted Dr. Tiggs. There's no indication that Dr. Tiggs was even aware that he was treating this patient. Interestingly, there was another physician from Orthopedic Associates who was on call at the time the plaintiff was admitted. That was a Dr. Carl Barbera, another shareholder of Orthopedic Associates, and it was Dr. Barbera who brought in Dr. Feinstein, who is the infectious disease specialist who took over the patient's treatment thereafter.
Well, you know, Counselor, Dr. Tiggs testified that he was not the attending physician, but he testified that it was the group that was the attending physician. How can a group, the OADC, how can that group act as an attending physician? Don't you need an actual individual physician as an attending physician?
That may be correct, Your Honor, but Dr. Tiggs was not that physician. I would say that if any physician from Orthopedic Associates was going to be the attending physician, it would be Dr. Barbera, since he treated the patient upon admission. He did a debridement. He brought in Dr.
But could
Feinstein.
the jury not have come to the determination based upon the evidence that since Dr. Tiggs' name was listed as the attending physician, and based upon all the evidence that Dr. Tiggs was in fact the attending physician, or at least responsible for the PA Caputo?
Your Honor, respectfully, he can't be responsible for he can't be responsible for PA Caputo, and he can't be responsible for the patient's treatment if he wasn't even aware of her admission. There were other orthopedic surgeons from the Orthopedic Associates of Dutchess County who were on call and were present during the day, and I would submit that at any given time, the physician who was on call, as Dr. Barbera was when the patient was admitted, that would be the attending physician, and that would be the physician who was responsible for supervising the care given to the patient, but not Dr. Tiggs, who had absolutely no involvement.
Thank you.
Good afternoon, Your Honors. Catherine Herr Solomon on behalf of the defendant appellant Orthopedic Associates of Dutchess County. The fundamental problem with this verdict was the jury's unwillingness to conform its verdict to the evidence. And the refusal to conform the verdict to the evidence is evident in all of the issues raised on this appeal. The jury ignored the undisputed expert testimony that Dr. Feinstein departed from accepted practice. It held the orthopedic physician's assistant liable for not monitoring.
What's happened here that the physician's assistant, Caputo, has been basically found liable, and Dr. Feinstein, who was in control of the case, has been found not liable.
Right. That finding cannot be reconciled with any fair interpretation of the evidence. When there is undisputed expert testimony on a departure from accepted practice, the jury has to have a basis. There has to be some other evidence for the jury to have disregarded that undisputed expert testimony. And in this case, there was no other evidence other than Dr. Feinstein departed from accepted practice.
I mean,
Wasn't there evidence on this record?
I'm sorry?
I'm sorry, was there evidence before this record by the dueling experts, both Dr. Gallagher and Dr. Wenglin,
right,
for the respective groups, that when each was asked a critical question, whether the acts of Dr. Feinstein, arguably negligent in not stopping the vancomycin earlier than he did,
right,
was a substantial factor that both, and I'm being overly broad because I don't have the actual transcript page in front of me, both were not able to give an opinion with a reasonable degree of medical certainty that his act of negligence was a substantial factor. Can one reasonably glean that from the transcript?
Oh, yes.
Okay, so hold that thought for a moment.
Okay.
So even if the jury erred in not finding Dr. Feinstein negligent on his question one,
right,
in the verdict sheet,
right,
even if that's true, but by not hitting the second element, there can be no case against Dr. Feinstein, true?
Well, but there was evidence as to proximate cause as to Dr. Feinstein.
Well, where did the experts say that?
The defense expert opined that Dr. Feinstein not only departed on the 27th, but departed on the 24th and the 26th, the 24th, 25th, and 26th. He basically abandoned the patient didn't call in and didn't inquire about her. So the jury had to answer the question as to Dr. Feinstein with a yes. It's plaintiff's position that that departure occurred on the 27th and that it was too late at that point. But there was plenty of evidence that he departed on the 25th and 26th, and I believe on the 24th, because he didn't do anything to have this patient covered by anyone in the hospital as to the monitoring of disinfection and the blood levels.
And on the 27th, does he increase the dose?
On the
Even though
27th, so
numbers-
that, yeah, I'm sorry.
Even though the numbers are going in the wrong direction.
Right.
The bun and the creatine, he increases the dose of the drug, right?
Well, he didn't increase it, he just didn't stop it.
He continues it even knowing the numbers are bad.
Exactly. And that goes to the argument that the case should really be dismissed, because PA Caputo, the departure is that on the 26th, he failed to notify Dr. Feinstein of the increasing levels. But we know from the evidence in this record that even if PA Caputo had notified Dr. Feinstein on the 26th, that Dr. Feinstein wouldn't have immediately stopped the vancomycin. He would have ordered a retest, and then the next day, he stopped the vancomycin. So in this case, if the evidence tells us that even if PA Caputo had notified Dr. Feinstein on the 26th, vancomycin wouldn't have been stopped until the 27th, and the evidence is undisputed that at that point, the plaintiff already was in renal failure, so there's no proximate cause as to PA Caputo.
Going back to Dr. Feinstein and the ultimate question, as Justice Shulman alluded to, he was asked at trial by plaintiff's attorney. The expert was asked, do you believe that departure, that is, Dr. Feinstein's departure, was a substantial factor in causing the acute renal failure? And this is his answer, and this is from the transcript. He answers, as we sort of discussed earlier today, it's tough to know at this point. I think the renal failure is pretty well established. You know what I mean? I don't know what one more dose did, but it's disappointing she got it. So I don't see him saying, based on that answer, that Dr. Feinstein's departure was a proximate cause of the renal failure.
That's plaintiff's expert.
Yes.
But the defense expert testified that Dr. Feinstein departed in multiple ways and that his departures were a proximate cause of the renal failure. So whether or not there's proximate cause, I think that the important factor is that there's no way that that answer no on the verdict sheet to the departure question was based on a fair interpretation of the evidence. I'd like to address damages. I can address them on my rebuttal.
Yes.
Thank you.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff respondent. Judge Shulman, I actually have the page references, and you're 100% right as to what, this isn't my expert, this is Dr. Wengling, and this is what he said on 387 of the record. Quote, and this is line 23 to 25, the vancomycin should have been stopped or could have been stopped. It wasn't, but I don't think in the end it really affected the outcome of Ms. Appleyard in this case. That's word for word. If you carry over to 393 and 394 of the record, this deals with Caputo and the other PA. Listen to this question. Question, if Dan Caputo, that's on the 26th, had contacted Dr. Feinstein on Sunday, or Courtney Tosi, that's on the 27th, had contacted Dr. Feinstein on Monday, would the outcome be different in your opinion? Answer. In my opinion, it probably would not have been different. I think the damage, if you will, to the kidney was already done. That's not my expert. That's their expert. So when you and Justice Mendez were talking about the record, I think that that's what the record shows. I would argue with respect to Ms. Goldberg's assertion that Dr. Tiggs isn't liable That argument, just to me, doesn't make any sense. Ms. Goldberg's a lot smarter than I am, but I don't understand it. The regulation says that PAs are allowed to work on the condition that they be supervised by a physician. The argument that the supervision was done by the group is a non sequitur. A group can't supervise, it has to be a physician.
Well,
This
that
is-
was my question, but, I mean, she's, as you heard, stated that Dr. Tiggs was not listed as the attending physician. I just don't know who the attending physician was. There's no listing, it just says, he testified that the group was the attending physician.
So, Justice Weber, if I can, I think that that statement is partially inaccurate.
Well, Tiggs was listed as the attending
Correct.
physician.
I think everybody
by the
says he was
abstract.
listed, and the reason he was listed isn't really all that complicated. Remember, I know we haven't gone into it yet, but she went in for a relatively minor arthroscopic surgery. She ends up with an infection that turns into a MRSA infection. I'm certainly not suggesting MRSA is not serious, but it is controllable. And then she sees the doctor who says to her, hey, this is you have renal failure. And she's a medical professional. She goes, not me, gives her the name, and this whole thing comes out. So I just don't think that that makes any sense. If the argument is, and if you read my adversary's briefs, and they're very, very good, the argument is that the group used PAs to be frontline treaters. They were there. If that's what it is, somebody has to supervise them, or they can't be there. So I think the liability against Tiggs is absolutely rock solid, legally, factually, professionally, and ethically.
So the liability against Tiggs is because Tiggs was responsible for supervising Caputo?
Yes, he would be responsible for supervising everyone in the absence of some proof that someone else was responsible. Because remember, when you read the reg says that a PA can't work unless under the supervision of a physician. They weren't even allowed to be there if that's the argument.
Yeah, but the fact that this orthopedic group had privileges to be there in Vassar Hospital, no one's disputing that Dr. Feinstein became the point person that took over after Dr. Barbero originally was working with PA Caputo to do the administration of vancomycin when she was admitted on August 10th. We're now already up to August 20th, and that's when Dr. ID comes in, and now he's taken over. He's ordered various blood level readings, peaks and troughs to determine, because it's very important for nephrotoxicity. He's doing everything right up to a certain point, and while they claim there was a gap from August 23rd to August 20, do I have that right?
The gaps from the 24th.
August 27th, right?
Yeah, August 24th to August 27th.
While they claim there's some kind of gap, we have Dr. Feinstein in the background, and the law is clear that the physician doesn't have to be there holding the PA's hand. So there is a physician working with PA Caputo. So now we're back to the issue of just because Dr. Teague did surgery 3 weeks earlier and his name is on the paper, and he's not the chief cook and bottle washer of this orthopedic group because there are multiple players there, including his own co-shareholder, Dr. Partner, who started administering the vancomycin, if I'm not mistaken. So it's not a case where you have one person who's the sole person who's specifically responsible for supervision and control of a PA here. That's not this case.
Well, that's fair enough. So let me respond to that. And if I can, in responding to your argument, I'm also going to, if I can, respond to Justice Friedman's observation about Dr. Feinstein. I think it's a misnomer, and I don't think it's accurate to say that Dr. Feinstein took over the care. If you read 327 of the record, which is the page that they reference, they're talking about a note. They say based on that note they took over. He's an infectious disease specialist, okay? He's not a frontline treater. He's not somebody who's in the hospital. That's what infectious disease doctors do. That's what consult doctors do. They look, they manage. And the most important fact relative to that I'd like you to consider, if you will, is the fact that when he went away, they keep saying he abandoned patients. He didn't abandon anyone. He said, listen, I'm leaving, everything.
Who was in charge of treating the infectious disease?
He was the infectious disease consultant. I don't want to make a play on words, Judge
So who was
Friedman,
making the decisions about how to treat that disease?
correct, but he didn't have to be in the hospital. And
No, but the question is who then would make those decisions?
I understand. I understand the argument. I'm going to answer the question directly. If you look at the note that I want you to look at, the note says, everything's okay. If there's a problem, call me. That's what I'm saying. I'm not saying he's not an infectious disease doctor. May I go over my time?
Please.
I'm not suggesting to you that he isn't the expert in that. That's what an infectious disease doctor is there for. But he's not culpable simply because he's an infectious disease doctor if he's not called by people who are frontline people. He
But
doesn't
could
have to be in the hospital all the
Could
time.
PA Caputo have actually made those decisions and actually have ordered the treatment?
Yes, under his testimony. He said he could have. He said he didn't because he thought that Feinstein was higher and he would do it, but he said he could stop the Vanco. He could.
From an orthopedic group?
I'm sorry?
You mean a PA from an orthopedic group is calling the shots?
No, I'm not, I did not say that. Judge Weber asked me a question, did he have the authority? And the answer is yes. Based on the record evidence, it's in all the briefs, no one disputes it, he could have stopped the Vanco, he could have ordered a retest, or he could have called someone. I'm not saying that he's superior to a doctor. He's not, he's a PA. It's like saying that, you know, a law assistant is not superior to a lawyer, but he did have that authority. So what I'm suggesting is there is a rational basis to the jury's verdict. It's not like he was in the hospital and he knew what was going on and he forgot. He left a specific note, call me. And that's what consultation experts do all the time. They're not treaters, they're consulting for a specific portion of the treatment as opposed to the overall treatment. If he had gotten a call and didn't show, I'm not here. Then absolutely correct. But I don't think the jury's verdict was wrong, and I don't think it was unsophisticated. I'm over my time, I'm sorry.
Thank you, Mr. Isaac.
Thanks.
Your Honors, I would like to point out very quickly that plaintiff's expert, Dr. Gallagher, specifically testified that Dr. Feinstein took over the treatment of the MRSA infection and was, quote-unquote, managing the antibiotics. That's at pages A327 and A339. In addition, there's testimony in the record that he called in consultants, and the nurse practitioner who accompanied him on rounds basically said that ID, infectious disease, was managing the patient. I also want to get back to the reason why BCL 1505 requires direct supervision and control. This was required as a predicate for imposing vicarious liability because the legislature, in allowing for the establishment of professional service corporations, did not intend to wholly exempt shareholders from the general rule of limited liability attendant to enterprises conducted in the corporate form. And that's the Weir Associates Company against Cohen, Stracker, and Bloom case, which I've discussed in detail in the reply brief. And I also want to point out that, may I just make one last point? Even though it's a Suffolk County Supreme Court case, the case of ML against Panza is very closely analogous to this case, held that vicarious liability would not be imposed on a physician who was a member of a professional service corporation who had no involvement in the patient's treatment. And I think it's very telling that in Mr. Isaac's very comprehensive brief, he doesn't make any mention of that case, let alone attempt to distinguish it.
Thank you.
Thank you, Your Honor.
Addressing damages, if the court is not inclined to dismiss the case or order a new trial on all issues, the grossly excessive award in this case actually warrants a new trial on all issues. Although typically the remedy is to reduce the award and order a new trial unless plaintiff stipulates to the reduction, the jury's lack of regard for the evidence in this case was so extreme that it calls into question the fairness of the entire verdict, and I would argue that the entire verdict should be set aside and a new trial should be ordered on all issues. If the court is not inclined to order a new trial and the award should be drastically reduced, the $3 million award that the jury made was for 3 months of pain and suffering, which included a brief period of renal failure, 3 dialysis sessions, and a return to a completely normal kidney function. So it would be our position that if the case is not dismissed, the award should be reduced to the maximum of $300,000.
Thank you.
Thank you.
Brzezinski versus Cross Management.
Good afternoon, Your Honors. May it please the Court. Anthony DiStefano for defendants appellants, Kraus Management and Franklin Kite Housing. There are triable issues of fact in this case regarding whether or not the plaintiff sustained a grave injury within the meaning of Workers' Compensation Law, Section 11. Plaintiff was struck in the head by a falling 2x4, and there is objective evidence that he did sustain a traumatic brain injury. So the question is, did that traumatic brain injury render him unemployable in any capacity? The plaintiff's employer moved for summary judgment to dismiss the common law indemnity claims against it on the basis of a report by a vocational rehabilitation expert who said that the plaintiff was employable in sedentary work. However, in opposition to the motion, we submitted the report of plaintiff's treating neurologist who said that plaintiff was permanently and totally disabled and that he was, in his opinion, he was unable to work even in a sedentary capacity. We also submitted the report of Dr. Houseknecht, who is plaintiff's expert neurologist, who said that he concurred that the plaintiff was totally disabled. The trial court focused on Dr. Houseknecht's report, and that's the finding that's in the decision, that Dr. Houseknecht never said that plaintiff was totally disabled from employment. However, I would argue that total disability is total disability from employment, but even putting that aside for a second, we go back to Dr. Fleischer's report, who's the treating physician, and Dr. Fleischer did say that he was not employable even in a sedentary capacity. So for that reason, on the initial motion in opposition, we raised triable issues of fact that should have gone to a jury. Failing that, after the motion was submitted, the plaintiff exchanged a report of his vocational rehabilitation expert. And that expert said specifically that the plaintiff cannot be expected to live alone, let alone return to work in any capacity. That's at page 2990 of the decision, of the record. So on renewal, we moved for renewal and we submitted that report saying, well, if Dr. Fleischer didn't do it and if Dr. Houseknecht didn't do it, certainly Dr. Schuster, who submitted this report, was enough to raise a question of fact. And in denying renewal, the court said, well, Dr. Schuster's report was part of the original motion, so you did not, this is not a proper basis for renewal. This evidence was before the court originally. Well, if that evidence, if that report was before the court originally, then that report clearly raised the question of fact that should have warranted denial of the motion for summary judgment. So for that reason, and because when we look at the Rubeus decision, the Court of Appeals specifically says that total disability means disability from employment in any capacity, and we have all of that here. We have Dr. Fleischer saying permanent and total disability, Houseknecht saying total disability, and Schuster saying unable to return to work in any capacity. Those are your questions of fact, and we should get a trial on those issues. Just quickly with regard to the contractual indemnity claim, the trigger here was whether or not the injury arose out of the work that was being performed by plaintiff's employer. Plaintiff's employer had subcontracted the installation of skylights to another entity. However, plaintiff was on site to assist that entity with that work. And the indemnity provision specifically provides not only for arising out of the work of plaintiff's employer, but also any subcontractor of plaintiff's employer. The trial court here conditioned our indemnity to the extent that the employer is found negligent for the incident. But that's not a basis in the indemnity provision. There is no limitation to the negligence of the employer or the employer subcontractor. It's simply arising out of their work, which this clearly did. So for that reason, on the contractual indemnity claim, the court erred by limiting our right to indemnity to that finding, and instead we should be entitled to full contractual indemnity based on the fact that we've been found liable to the plaintiff under 240. Thank you.
Thank you.
Good afternoon. I'm Darian Bryan on behalf of Skylights, the respondent. In regards to the issue as to whether plaintiff sustained a permanent disability as a result of an external factor, our doctors, we submitted medical evidence from Dr. Carmen Velasquez, a neurologist, who examined plaintiff and found that he was able to return to work and perform.
So why doesn't Dr. Fleischer's affirmation create an issue of fact?
I think the issue with Dr. Fleischer's affirmation is that he conclusory stated that plaintiff cannot return to work. And then there's also an issue as far as plaintiff, Dr. Fleischer, testifying previously at a workers' compensation board hearing that plaintiff could still do sedentary work. So his own testimony conflicts with his report after that, and as well as the reports of our vocational examination by by Peter Capizotto, who also stated that plaintiff could do sedentary work after the accident.
What about Dr. Schuster's affidavit?
I believe Dr. Schuster's report was also conclusory, as it also fails to address plaintiff's own deposition testimony, where he mentions all the things that he is still able to do as far as reading, writing, driving, grooming himself, shaving, and then he also never testified that he also never received any medical notices from any doctors stating that he could not work in any capacity following the accident. And then in regards, I'm sorry, are there any further questions? And then in regards to the matter as far as the contractual indemnification, I believe that the court properly found that the contractual indemnification should be based on whether Skylight was negligent or not. The language in the contract is not limited in any manner as far as whether it is triggered by negligence. And that in itself, I believe, runs afoul of the general obligations law. And I believe that the court probably found that
But there's no evidence on the record that the principals that are vicariously liable under 240, there's nothing here that suggests that there was any liability real time on behalf of the owner or managing agent here.
No, I believe it was.
So GOL would come in only in the real sense if it was going to shield or seek indemnity against their own negligence. There's not an issue in this record whether they were negligent at all. They're just on the hook statutorily.
Correct.
So given that, then there's nothing wrong with this open-ended type indemnity clause, what would be the basis for conditioning it?
My understanding was that the basis for conditioning it's because the negligence on our client's part, my client Skylight, is not there yet or hasn't been determined yet, and there's no limitation as far as that in the contract. I believe that it should have been limited based on the court's findings. And with that, I would just ask that the decision be affirmed, and I thank you for your time.
Thank you.
Does the indemnification run afoul of the GOL?
No, it does not, because first of all, it's to the fullest extent permitted by law, which we know from Dutton and other cases is the quote-unquote savings language.
Makes it permissible.
Correct. And in this case, we were not negligent anyway. I believe the negligence claims against us have been dismissed. So we would not be, there would be no reason to void it, even if it did not have that savings language. With regard to Dr. Fleischer's conclusory statement, Dr. Fleischer is the treating physician. I don't think that there would be anybody in a better position to make a statement about what type of work the plaintiff could do than the treating physician. With regard to
Did your adversary just state that Dr. Fleischer's statements were contradictory to a statement made previously?
Right, so what they're referring to is a workers' compensation board decision, a recitation of what the board believed that Dr. Fleischer testified to. It was not Dr. Fleischer's actual testimony. That's not in the record. And then with regard to the daily living, well, two things with regard to, one more with regard to the work, if I may, Your Honor, is that plaintiff testified that he was specifically told that he could not work. It says, initially after your accident, did any of your doctors tell you that you would not be able to work in any capacity outside of construction? It's page 904. Answer, I think so. And he repeats that testimony a couple of times. He does at one point later on, after about the fifth or sixth time that he's asked, say, no, no one told me. However, up to that point, he did testify that they had told him he would be unable to return to work. And then just real quickly again, Your Honor, if I may, regarding the daily living, he said he can shower as long as there's no barrier for him to step over. He He could not drive any longer. He could no longer do chores in the house. Yes, he could write, but he was very slow. He has a significant problem with his memory. He has a severe brain injury. It takes him more time to write than he used to, and he was told that he would have that brain injury for the rest of his life.
Thank you very much.
Thank you very much.
Scarola, Zubotov, Sharzan, PPP LLC versus Dynamite Credit Partners.
Alexander Zabata for the plaintiff appellant. May it please the court. The court below in this case premised its decision holding that we could not show reliance on our fraud claim in the case on its view that we were simultaneously arguing two alternative accounts of facts, and that is simply incorrect. We have a very clear position in this case. We had a fee agreement that entitled us to be paid our fees. They did not pay us the last $10,000 or so in fees. We had a conversation with the defendants in February 2013 in which they tried to get us to modify that agreement to forgive that last $10,000 in fees, claiming, as we later discovered falsely, that they had not been reimbursed for those fees by their counterparty in an underlying
There's no
transaction.
question that you have a contract here for the fees.
Well, I'm sorry, Your Honor, the original retainer agreement.
Position that there's a retainer agreement which provides for you to collect these fees.
There's a retainer agreement. Now, they claim we agreed to modify.
That you waived part of those fees.
Correct.
So, and you say, to the extent that maybe we waived it, there was fraud.
Well, we say...
You were fraudulently induced to waive the fees because the defendant told you, oh, he can't afford to pay or it can't afford to pay and they're not, and it turns out you say, I think that they were reimbursed from someplace else, so they certainly could have afforded it. So that's the issue here, isn't it?
Well, Your Honor, yes, except I would say the following. Our position is clear that we did not, during that conversation in February 2013, in fact, agree to modify the contract, okay? But they also made that false statement to try to get us to agree to modify the contract. And they are saying the contract was modified. If a jury, this case goes to a jury, they're going to be arguing to that jury that we modified the contract. We are entitled to show in response that, well, actually, that modification was secured by your fraud, if there was such a modification. And so it's really a routine situation in which a plaintiff brings a breach of contract claim, a defendant says, well, we don't believe there was a binding contract for various reasons, and the plaintiff adds an unjust enrichment or quantum merit claim in the event that the defendant can persuade the jury there's no binding contract. We get compensated this other way. This is exactly the same situation. The only thing, the one and only circumstance that makes this case a little bit different, which I believe is what misled the court below, is that the way this unfolded procedurally is in two separate cases, where the breach of contract case was initially brought in the civil court, and then the fraud and unjust enrichment claim in the Supreme Court. We made a motion to consolidate that the court below denied as part of this appeal as moot after dismissing the underlying claim. But once that motion to consolidate is granted, it becomes that same garden variety case. And the part of the reason we brought that motion to consolidate is because they are asserting wildly inconsistent positions. Their core argument is that we agreed to modify the contract so that they're not obligated to pay those fees. And yet, they are arguing on this motion, have repeatedly argued that it is indisputed there was no contract modification. It just cannot possibly be squared, and it's clearly in the record and should not be permitted.
I just want to clear one thing. After that so-called February 13 conversation between Mr. Finkel and your principal of your firm, they paid about $10,000 the following day. Did I read that right in the record? Didn't they pay a portion of the fees?
No.
How do they claim accord and satisfaction? How do they claim as one of their defenses a court in satisfaction? Your original claim was for about $20,000, right?
Your Honor, the final 10,000 in fees was not paid. I was not involved in that earlier stage of the proceedings, and I'm not sure what the basis for the accord and satisfaction defense is, but it is very clear, I think both sides agree, that the last 10,000 was not paid. The only question is whether or not they had a right not to pay it. And based on, again, if they are going to argue to the jury that you agreed to modify the contract, are we really precluded in that case from saying, well, in fact, they lied to us, so if you, the jury, agree with them, then it was fraudulent inducement. And then the motion to consolidate should also be granted to prevent inconsistency between this case and the civil court case. Thank you.
Thank you.
Timothy Cohn on behalf of Respondent, Your Honors. In our brief, we quote the portion of the New York law that says, "Conduct is frivolous if it is completely without merit and cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law." This is a case that meets those stringent criteria, and that is why our brief has reserved a motion for sanctions. This law firm sued its client for $10,000 in unpaid fees, did so years after the conversations to which you, Justice, alluded, in civil court. Then, once it was unhappy with a civil court ruling, it kept that civil court case going and now sued for fraud and unjust enrichment in Supreme Court. So we now got 2 cases going. So we're already here in what could be called la-la land, going after a former client for $10,000 in 2 separate courts, taking up valuable judicial resources, and of course, the time of the client who now stands accused of fraud. In the Supreme Court, we point out to the judge that it is well-settled law that you need to show reliance if you're going to claim fraud. There was no written release in this case. There was no change in position based on the conversations. There was
Well, if the client tells the attorney, you know, we can't afford to pay, we're not going to get reimbursed for this, and therefore, could you waive the rest of your fee? And then it turns out that, in fact, the client was reimbursed for those legal fees by a third party. Is there any reason the attorney can't pursue seeking to obtain that fee?
Sure, he can sue for contract damages and try to obtain that fee. And if he feels he was fraudulently induced to agree to the lower fee, he can make that argument.
Well,
But that's not fraud.
Isn't that exactly what they're claiming here? The client told us they can't afford to pay, and then it turns out that they were reimbursed for those fees, and based upon their representations to us, we agreed to let that fee go.
They did not agree to let that fee go. As I mentioned a moment ago, Justice, they sued for those very fees in court. They have not released their right to those fees in any way.
Wasn't the amount a lot higher than $10,000?
No.
The original amount, wasn't it?
The original amount was $50,000. Yes, the bill was $50,000 an invoice, and the $10,000 of that was left unpaid. And so we're talking here about the $10,000 that was left unpaid. And here we are in the Appellate Division, First Department.
Do you dispute that there's an agreement, that there was a contract between the parties that obligated your client to pay
No.
the $10,000?
About the legal, I'm sorry to interrupt. About the fees, no. There was an agreement between this client and this lawyer that legal services would be performed and the lawyer would be paid. So, Your Honor, as I have mentioned, and as we say in the brief, we are reserving a motion for sanctions based on the briefs in this case. Thank you. If you have no further questions.
Thank you very much.
My adversary just said that once again, that there has been no change in the parties' positions based on conversations. They stated in their pleading in this case, I'm quoting, record page 181, defendant and plaintiff reached a fee reduction agreement, okay? That appears in the civil court pleading, our record 189 to 190. It's in a sworn affidavit that's quoted at R133 from his client, okay? Fee reduction agreement. And yet, their brief in the court below says, quote, it is indisputable that Scarola did not agree to reduce his fees. That's R72. At oral argument in the court below, they doubled down on that view. They said there's no agreement to reduce fees. That's R22. Okay, and he said it again here. They cannot be saying both things simultaneously, all right? And that's the reason for the consolidation motion that we have made, and that's the reason the fraud claim has to be revived, to protect our rights when they make that argument to the jury that we reached a fee reduction agreement. We're entitled to say, no, it was fraud. Thank you.
Counsel, just a question. How is there a viable unjust enrichment claim if there's an actual contract here?
Well, again, this goes back to that garden variety situation. We say there was a viable contract that covers this entire transaction, including that final $10,000. But they deny that that final $10,000 is covered because they say there was a modification of that contract that we agreed to, okay? We disagree that we made that modification, but
it's still a breach of contract based on the remainder of the fees you believe you're entitled to.
That's correct, but we're entitled to argue to a jury whenever a defendant in a case like this questions the validity of the contract or whether the contract applies to that last $10,000 fees, we're entitled to say, okay, well, unjust enrichment, if the jury happens to agree with you. Just as we're entitled to say fraudulent inducement, if the jury happens to agree with you that we did accede to this request for modification, it was secured by your client's fraud. Same idea.
Thank you very much.
Thank you.
885 3rd Avenue versus Alden Global.
Good afternoon. Gary Mennett for defendant appellant Alden. May it please the court. This is a commercial lease case and I represent the former subtenant. The issue presented is one of basic fairness. A property owner does not have an unwritten unilateral option to hold a subtenant for rent when the owner itself canceled the ground lease and is not bound to the subtenant.
Sir, wasn't Alden in occupancy? Just for purposes of our discussion, there's no dispute that Alden remained in occupancy, in possession and control of the demise premises on the 34th floor, minimally from April 2020 through January, whatever date they accepted your ultimate cancellation or termination or vacature, 2021, correct?
There is no question that Alden was in occupancy for some period of time and that we refused to pay rent to the owner.
Correct, and there's no dispute on this record that Metropolitan, their cancellation, their termination, et cetera, took place the end of July. of 2020.
That's correct, Your Honor. What happened was that the owner canceled Metropolitan's lease at the end
Correct.
of July, yes.
So you were in occupancy, so occupancy is not an issue. So then, let's take what may be the easier issue. Because as I understand it, Justice Schechter, on a 3211, A1, A7 motion, basically said, did they more or less have a cause of action for quantum merit in terms of use and occupancy, even if they didn't use all the right buzzwords? You hear what I'm saying?
I think that's a fair characterization of her decision. The problem that I have with her decision is that if the complaint had 3 claims, 2 claims for expressly for rent, and they do not state the elements that Your Honor just set forth from quantum merit or use and occupancy. They only set forth the elements for rent, and then there was a 3rd claim that Judge Schechter correctly dismissed, and that's not.
To freeze your assets.
Yes.
So getting back to the first point and the main point, it is your understanding that because your sublease, which was executed in 2016, was executed after the 1995 original ground lease, that Section 6.01A, the quote, attornment section, which would have given them the automatic right to establish a relationship with you, doesn't kick in. It really 6.01B.
That's exactly
would have
correct.
required more formality. Do you want to please attorney to me and step in the shoes of Metropolitan, correct?
That's exactly correct, Your Honor. And we don't dispute that if 601A were the applicable provision, then there would be no issue here. But what 601A says, and 601A does contain a very broad attornment, and if that were applicable, we would be subject to attorment. But what 601A says of significance here is it says subject to 601B. So it says you have to attorn to everything subject to 601B, and then 601B says notwithstanding 601A, so 601B is clearly the dominant provision. It says with respect to any hereafter created underlying lease, and it defines that as an underlying lease which does not exist as of the date of this lease. And this lease is 1995. That's on the very first page of the lease at page 55. So what the plaintiff here is forced to argue is that when the 2016 Fifth Amendment, that's the only contract that Alden is party to, when that Fifth Amendment says that words and phrases used in this agreement but not otherwise defined herein shall have the meanings ascribed to in the lease, defined to mean the 1995 lease. What they meant was as ascribed in the lease, except that when the lease, the 1995 lease, defines itself as being the lease in 1995, it really means in this lease or any subsequent lease. And they say in their brief that the alpha and omega here is the Dime Savings Bank case, the Court of Appeals case. But it really is the death knell for them, that case, because in that case, what happened was that the earlier lease, that case involved a mortgage, and the mortgage issue is a separate issue. But what happened in that case is you had a somewhat similar fact pattern otherwise. You had an earlier lease in 1982, a mortgage in 1987, and then subsequently an extension. And in the original lease, it said that you're subject and subordinate to all mortgages which may now or hereafter encumber the property. So we don't dispute if that's what our 1995 lease said, that we would be stuck. We would be automatically attorned. But here, it said you're automatically attorned to everything except subject to 601B, which said you're not attorned to anything that arises after 1995, unless you agree.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. James Schwartz for Respondent 885 3rd Avenue. The Dime Savings Bank case does control here. Even though it arises in a mortgage context, it's
So
applicable.
does this fall under 601B?
No, it falls under 601A, not 601B. It falls under 601A because the Fifth Amendment under the Dime case is such a change to the 1995 lease, and the Fifth Amendment was made in 2016. It's such a change that it is considered under Dime a new lease for purposes of the superiority question. It's a new lease because, number one, it extended the term significantly. The old lease was to run out in 2017. Now, under the Fifth Amendment, 2025. There was a $400,000 security deposit that was put up for the first time. There's a new party to the Fifth Amendment, which had never appeared before. The rent increased. Remember, we're here, Your Honors, on a motion to dismiss for legal insufficiency. It is certainly not insufficient as a matter of law that the Fifth Amendment could be considered a new lease. What we face potentially is a factual issue which is not susceptible to resolution on a 3211A motion. And there is nothing in the documents that absolutely refutes the argument that the words hereafter created cannot refer to the relationship between the 2007 ground lease that was terminated and the 2016 new sublease, that is by way of the Fifth Amendment. The Fifth Amendment incorporated by reference certain provisions from the underlying lease, just as happened in Dime and in another case that I have cited from the Eastern District of New York. And that case, I think, is something with a V. You'll bear with me for a minute, Your Honors.
So that I understand you
That's
correctly.
north. That's north.
I'm sorry, so that I understand you correctly. If, for the sake of discussion, Alden would have exercised the option to extend the 2007 renewal that was in place beforehand. It was 2007 to 2016. And then instead of, as you say, creating a Fifth Amendment or a new lease with new terms, simply accepted the option or extended it, then you would argue the 6.01B controls.
Well, I wouldn't necessarily argue, but their position would be a heck of a lot stronger than it is. But no option was exercised pursuant to the lease or the first four amendments. An entirely new term was granted.
So your position really is just put the mortgage aside and just apply our fact pattern to the Dime case. And because it's a new lease in 2016, therefore, which incorporated the 1995 original lease in it, correct?
It did not incorporate the 1995 original lease,
did.
but it incorporated terms.
I meant the terms. It incorporated
Fair enough. I'm sorry, Your Honor. I've forgotten your question. But that the terms went into the new into the new lease does not mean that the old lease continues to control, particularly since you've got a new party on the Fifth Amendment that did not appear anywhere in the original lease or the first four amendments. And the words hereafter, Alden was on the Fifth Amendment, but it did not appear as the tenant or subtenant on anything that preceded that. But what the words hereafter created, which are projected, that 6.01 in the 1995 lease is now in the Fifth Amendment, which we say under Dime is effectively a new lease. And the words hereafter created in that 6.01 or 6.01 now relate to the Fifth Amendment. They are not defined in the 1995 lease. Hereafter created is not defined. It refers there to the 1995 lease, but it's not defined. Now, the term hereafter created, taken into the, incorporated by reference into the Fifth Amendment, refers to the Fifth Amendment as a new lease for superiority purposes under dime.
So for the sake of discussion, let's say there was a new sublease was created after 2016. In other words, this one was extended to 2025, correct? Yes. But let's say somehow there was a modification. In your opinion, that would be something that would be hereinafter newly created, which could arguably trigger 6.01B after 2016.
Precisely. And the lease here my time has run out. May I conclude?
Yes, please.
The lease here that the tenant says was not hereafter created was created, what was hereafter created, it relates to a 2007 overlease, which was not hereafter created. The 2007 overlease preceded in time and preceded in superiority the 2016 sublease. Thank you very much, Your Honors.
Thank you.
I understand Appellee's argument, but it is just completely inconsistent with what the parties agreed, and this is just a straight contract case. In the record at page 112 is the Fifth Amendment to lease, which is the only document that Alden signed. And on the very first page, which is 112, they define lease to be to include the 1995 lease in the four amendments. No one has argued that there's anything relevant in the four amendments. So it's the 1995 lease. And then it specifically says in the very first paragraph, words and phrases used in this agreement, meaning the 2016 agreement, but not otherwise defined herein, shall have the meanings ascribed in the Inishcap lease. The Inishcap lease is the 1995 lease, and the 1995 lease, my adversary misspoke. He said that 601B does not define the underlying leases, that the existing underlying leases that we would be subject to. That's just not correct. The very first sentence of 601B says, any hereafter created underlying lease, i.e., that's the definition, i.e., an underlying lease which does not exist as of the date of this Inishcap lease. And this Inishcap lease is defined in the agreement as being 1995. So anything after 1995, they had to get a specific, they had to give us a non-disturbance agreement, that's the quid, and then we had to give them a recognition agreement, that's the quo. But there had to be a quid pro quo. I just want to address one thing in Dime. There are basically two holdings in the Dime case. And I think my learned adversary is mischaracterizing them. So the first holding is that the mortgage prohibited prepayment of rent, right? You can't accelerate the rent and give it to the owner and thereby degrade the collateral that the mortgage company had. That is a mortgage issue. It's got no application here. No one has argued that that has any application here. With respect to the attornment issue, the court did exactly what I'm asking this court to do, which is they just looked at the terms of the earlier lease that were incorporated by reference, and they said this is in the second to last paragraph of the decision. In any event, pursuant to paragraph 7 of the 1982 lease, incorporated into the 1992 lease, the tenancy is subject and subordinate to everything that may now or hereafter encumber the property. That's 601A. But our lease says you are subject to everything in existence, but with respect to anything that arises after 1995, they had to come to us and say, we'll give you a non-disturbance, you give us an attornment. They never did that. There is no such agreement.
Thank you.
Thank you, Your Honors.
People v. Ashley Williams.
Good afternoon, Your Honor. My name is Joseph Teknis. I'm a law student intern in a criminal defense clinic at Cornell University, appearing for Mr. Williams. I'm joined today by my clinic supervisor, Kate Skolnick, from the Center for Appellate Litigation. I would like to spend my time today discussing the trial court's failure to consider the lesser-included offense of third-degree reckless assault. The trial court's failure to do so requires this court to vacate Mr. Williams' conviction and remand his case for a new trial. A rational fact finder, viewing the facts in the light most favorable to Mr. Williams, could have concluded that he did not want to cause the complainant to suffer physical injury, but that he was reckless with respect to that result.
Counsel, how would this be reckless conduct? I mean, I watched a video. It does not seem that it was reckless. It would appear to be intentional in terms of the way the defendant struck the 84-year-old victim.
Your Honor, there's a possible hypothesis that Mr. Williams acted recklessly with respect to the physical injuries that the complainant suffered because Mr. Williams did not necessarily use a level of force which would require any rational fact finder.
The victim's glasses were broken and they were completely knocked off his face.
Yes, Your Honor. However, Mr. Williams did not use a level of force which would require any rational fact finder to conclude that he wanted to cause physical injury. And I think
How did the complainant sustain a fracture?
He had orbital fractures,
Orbital
I believe.
fracture.
Yeah.
yes, Your Honor. A rational fact finder, if this court disagrees with us on point one, could possibly infer that Mr. Williams intended the natural and probable result of his conduct. But they're not required to make that inference in any.
You mentioned possible hypothesis. Is that the standard by which we decide whether there should have been the reckless charge given?
The standard is, Your Honor, viewing the facts in the light most favorable to Mr. Williams and drawing all inferences in his favor, whether a rational fact finder could adopt a single possible hypothesis supporting guilt for the lesser but not the greater offense. And that's possible here because viewing the facts in the light most favorable to Mr. Williams, it's not clear that he punched the complainant. It's possible that he used an open.
I'm sorry, it's not clear that he punched the complainant?
Yes, Your Honor.
You look at the video, don't you? Doesn't he stand up and he's yelling at the victim because allegedly the victim disrespected him or something of that nature? And then he punches the victim again, causing the orbital fractures, causing the broken glasses, causing the glasses to fly off his face, causing, I think, 10 to 20 stitches, something of that nature.
However, Your Honor, the video does not show Mr. Williams form a fist. It does not show him punch the complainant. It doesn't capture any of that conduct.
But there's testimony, right, from the individual inside the deli?
There is testimony from Mr. Yang, Your Honor, but Mr. Yang was standing behind a window that was almost entirely covered by advertisements.
But on top of that, isn't there also, in essence, almost like an admission from Mr. Williams? He said he hit the complainant.
He said he hit the complainant, Your Honor, but it's not clear that he punched the complainant. And even if this court thinks that Mr. Williams punched the complainant, I think it's important to recognize, in comparison to the facts of a case like People versus Feldhausen. And in that case, the defendant there, in a domestic dispute, slammed his girlfriend's head repeatedly against the bedroom dresser, then stood her up and hit her so hard that she collapsed to the ground. And the Fourth Department said there that there was a possible hypothesis such that a rational fact finder could conclude that the defendant there recklessly and not intentionally caused physical injury. The Glover standard is forgiving to defendants and favors giving instruction on a lesser included offense. And here, due to the fact that the incident happened, as the people stated, for frankly inexplicable reasons, due to the fact that the only eyewitness is saying that he formed a punch had a faulty memory and a bad view, and due to the fact that following the incident, Mr. Williams did not show consciousness of guilt, those all form a factual basis by which a rational fact finder could conclude that Mr. Williams did not necessarily want to inflict physical injury, but that he was reckless, that he ignored the risk that his actions in an objective.
So do we look to the fact at all that we're talking about an 84-year-old individual? I mean, obviously, the individual was older. Do we look to that at all?
The fact that the complainant was older, Your Honor, supports a finding that Mr. Williams was reckless, because it's objectively unreasonable that if you were to hit an older person in the face, that they might suffer a physical injury. But it supports recklessness here because although it's objectively unreasonable, there's the possibility that he ignored that risk and took his actions anyway. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court, Emily Galt for the people. The only view of the evidence here is that defendant intentionally caused physical injury to the victim. Defendant, of course, admitted in his statement to the police officer that he hit the victim, he hit an elderly foreigner, he admitted that he knew he was going to jail, and he even asked how the victim was doing. The injuries, this isn't something that was caused recklessly. I urge Your Honors to look at the photographs of the victim if you have not already, because they speak volumes of intent here. The victim's eye swelled shut immediately. He was bleeding from the head. He suffered multiple orbital and facial fractures. He was in the hospital for a month and then was released to a rehabilitation center. This is not something that's caused recklessly. Defendant clearly intended to cause these injuries, so the judge was proper in declining to consider reckless assault. If Your Honors would like me to address any of the other points in the brief, I'd be happy to do so. If not, we rely on our brief.
Thank you very much.
Thank you.
The people are wrong to assert that the extent of the complainant's injuries are themselves a sufficient basis to reject giving the lesser included offense. And that's because even when there is convincing evidence of guilt of the top charge, the trial court is required to give the lesser included offense instruction so long as there is a possible hypothesis drawing all inferences in the fact finder's favor, in the defendant's favor, that he's guilty of the lesser and not the greater of the offense. And here, the injuries themselves are not a sufficient basis because while it would be permissible for a fact finder to make an inference that a defendant intended the natural and probable consequences of his actions, making all inferences in the defendant's favor, the fact finder wouldn't necessarily make that inference. And here, due to the fact that Mr. Williams, as the people stated during trial, that this incident occurred for frankly inexplicable reasons, due to his history of severe mental health issues, due to the fact that there was no reliable objective view of what happened, and that a rational fact finder could have rejected part of eyewitnesses' testimonies supporting the greater offense, this court should vacate Mr. Williams' conviction and remand for a new trial. Thank you.
Thank you. What year law school are you in?
A third-year law student.
Oh, excellent job. Hope to see you in a couple of months after you pass the bar.
Thank you, Your Honor.
Good luck.
Thank you.
Fundo de Recupiaso versus Gago Aracola. Justice Friedman is accused. You are well aware of the rules of this court. If there is a tie, another judge will be vouched in.
Good afternoon, and may it please the court. Catherine Clemente on behalf of appellants. A hallmark of the order on appeal is a misinterpretation of the settlement agreement. First, on our Champerty defense. The lower court erred in finding that appellants waived their Champerty defense pursuant to the settlement agreement. While the settlement agreement included a broad waiver of defenses, as a matter of New York law, appellant's Champerty defense could not have been waived, as Champerty is a misdemeanor under Judiciary Law, Section 489.1. This court recognized as much in Red Tulip. In that case, this court underscored the authorities suggesting that a statute enacted to protect the public interest, such as Judiciary Law 489, is unwaivable. It is for this reason that the lower court's determination was erroneous. The lower court also erred in determining that appellants cannot now challenge the assignment because they conceded its validity in the settlement agreement. There are two problems with this finding. I'd first like to direct the court's attention to the record at pages 317 through 319. On the settlement agreement's face, there is no provision acknowledging or conceding the validity of the assignment. In fact, the word assignment appears nowhere in the settlement agreement. Thus, the lower court erroneously read such language into the agreement. But even if this court were to adopt the lower court's construction of the settlement agreement in that sense, which we maintain is erroneous, to find that appellants conceded the assignment's validity, such a concession could not then serve as a waiver of the Champerty defense or acquiescence to Champerty's conduct. New York law.
Question. Didn't the court approve the assignment back in November of, I believe, 2017? I was under the impression that the court approved the assignment.
So the court in Brazil did.
That's a yes or no. That's it. It's either they did or they didn't. I thought they did.
Yes, the court in Brazil did approve the assignment after entry of the judgment against my client. This was after my clients had lodged their defenses and in the midst of their appellate process. Our position, however, is that when defending against domestication of a foreign judgment, one of the discretionary bases is looking at New York public policy. And our position is that assignment violates New York public policy. So whether the Brazilian court approved.
Why would it violate New York's public policy? It appeared to be the Brazilian court, as stated by my colleague, approved the assignment. The Brazilian court was aware of the facts of the case, of what was going on and what had occurred. So how would this be against the public policy of New York?
Because there were markers of Champerty in the underlying assignment, which is illegal in New York. So we have an assignment that occurred with ostensibly the intent and purpose to sue upon a claim in New York. This is not as simple as purchasing a domestic judgment with the intent to collect upon it. A foreign judgment.
Didn't the default already occur? And this was just really a ministerial matter just to convert, no?
In the lower court, Your Honor?
What we're talking about right now. You were already in default, right?
That is the allegation, correct. And so that is the allegation. However, these are
deny that there was a default? You deny that there was a default?
We don't deny that there was a default.
Oh, so there was a default.
Your Honor, our position is that these are the defenses our client was legally entitled to below, and that the settlement agreement did not bar these defenses because these defenses were non-waivable under New York law. And if I make... So even if this court were to adopt the lower court's construction of the settlement agreement to find that appellants conceded the assignment's validity, such a concession could not then serve as a waiver of Champerty. So we run into the same issue as before, whether evaluating the waiver provision of the settlement. Yes, Your Honor.
I'm a little confused, so forgive me. Based on a law of comedy, we have a Brazilian judgment that the plaintiff comes to New York to enforce. You have to go through certain ministerial steps. But as I understand it, the judiciary law does not bar or prohibit the purchase of a judgment for purposes of collection. That's in the law.
Correct, Your Honor.
So respectfully, where's the Champerty here?
So the difference is the nature of the judgment. A foreign judgment is not a judgment until it goes through the ministerial process. So at the time of the assignment, the Brazilian judgment was just like any other claim for which an action or proceeding must be commenced, and that falls squarely within the ambit of the Champerty statute.
Well, that was the whole point. I thought that the Brazilian court's assignment of the debt was based upon a default. There was a determination by the Brazilian court that monies were owed, and that those monies were assigned. And so there was a proper assignment, and so now that was brought to the New York courts.
Well, our position is that the assignment under New York law is illegal.
So what's the authority for that? What's the authority for it?
Judiciary Law, Section 489.1.
Which does not prohibit a purchase of a judgment by one engaged in the business of collection and the judgment of claims for the purpose of enforcing the judgment's collection.
Well, Your Honor, as we note in our reply brief, there's case law, the Biblos Bank case, the Servas case, and the Weston Capital case. Those cases provide that a foreign judgment is not a judgment until it has been recognized and domesticated. So at the time of the assignment, a judgment was not purchased. It was a claim that was purchased because it was not yet a judgment under New York law. And I see my time is up. I'll reserve the rest of my time for rebuttal. Thank you.
Good afternoon, Your Honors. Gonzalo Zabayos of Baker Hostetler for Respondent.
Could you respond to your adversary's last argument or statements concerning the assignment of this debt and whether it's ministerial or not in terms of New York?
The process of recognition and enforcement of foreign judgments in New York is, as you said before, a ministerial process. The recognition process has been modernized in New York such that there is no separate recognition application and a separate enforcement application. They're brought as a single application, and the basis for rejecting that application are extremely limited. New York State is considered to be one of the most receptive, one of the most favorable states for recognizing and enforcing a judgment. Now here, that recognition and enforcement is made all the more simple by the fact that we have a settlement agreement by which and we disagree with appellants, where we say there's an admission that the underlying assignment is valid. Why? Because there's a statement that says, that acknowledges that the monies are due and owing to FRA, to respondents.
Right, and so your adversary seems to be arguing that that the court, Supreme Court, should have looked at that assignment, should have made a determination as to whether or not it was, I guess, a valid assignment or not?
But they're essentially, our position is that they're boxed into their admission as to the validity of the assignment by acknowledging that the monies are due and owing, by waiving defenses and objections under paragraph 6 of that settlement agreement, but even more importantly, by performing under that agreement. And as Your Honors have correctly noted, Champerty is just not at issue here. If we look to the cases, Justinian 1 that they cite to, which is one of the seminal cases interpreting the Champerty statute, they say New York draws a distinction between one who acquires a right in order to make money from litigating it, and one who acquires a right in order to enforce it. And then they explain the relevant inquiry is whether Justinian bought the instruments as a bona fide investment, which would properly include the ability to enforce rights through litigation, or if the purchase was merely a pretext for conducting litigation by proxy in exchange for a fee. Now, this settlement agreement would be a very poor example of Champerty because its whole point was to do away with litigation. Our clients don't want to be here. That's why we put paragraph 6 into the settlement agreement. This is not a case where the purpose of the assignment was to generate a fee through litigation. It was a case where the purpose of the assignment was to enforce a right, a judgment. And precisely what Justinian says we can do, precisely what Section 489 says we could do. The only reason we're litigating this case is because of appellants, not because of us. Unless you have any further questions, I have nothing more to add on this point.
Thank you.
Thank you.
So, counsel, is your argument that Supreme Court should have looked beyond the settlement agreement and looked beyond the assignment?
Our position is that the Supreme Court should have evaluated the assignment because what this action was for recognition of the Brazilian judgment.
But what would give Supreme Court the authority to do so? And I will say that there was, my recollection is that there was the assignment, there were accompanying documents in terms of the litigation in Brazil. I think there was an affidavit as to the facts of the case, the law in Brazil, et cetera. that was attached to the assignment as well, to the stipulation as well.
Indeed, there was. Our position on that affirmation is that respondent's Brazilian counsel could not have provided personal knowledge of the underlying assignment's intent and purpose, because that is the dispositive question here that we submit that the lower court should have evaluated.
So again, that's my question. What authority do you have that states that Supreme Court had the authority, the jurisdiction, the ability to look beyond the papers, the assignment that was presented to it?
Oh, under CPLR 5304B, that's the public policy discretionary defense, and also because respondents still needed to satisfy their summary judgment burden, such that when their prima facie burden wasn't met, and there was a fact issue as to Champerty, the lower court should have allowed us to conduct Champerty-related discovery.
Thank you.
Thank you.
Thank you both.
Thank you.
Lee Thai Enterprises versus Dagan.
Good afternoon. My name is Max Leifer. I represent the appellant in this case. The reason this case is being brought forth is that there was a motion for summary judgment, or actually denying the rights of the defendant to present his case. He's pro se. He presented two major factors. One, that he was locked out as a doctor in the building. And
How was he locked out? I think it was March 20th, there was a notification that the building may possibly close. And then March 22nd, there was another email stating that, no, the building is not going to be closed, and also because you render an essential service, right? And it stated that the building will be open during certain hours, and if you need access to the building after those hours, you have a key card, and so you can access. So how was he locked out?
That's not what happened. He was locked out. He went to the building to use it. If you read his papers, his pro se papers, and they didn't let him in. And not only that, there was a problem with the electrical system, which they were supposed to protect the building, and all his equipment got burnt out.
I thought that was in 2017 when there was a power surge from Con
Right,
Ed.
and what happened was they made an agreement that there would be a pending action against Con Ed, which is in lawsuit, and that agreement would be the basis of catching up on the arrears of the payment. He clearly sets it forth in his arguments. I mean, he's entitled to, first of all, there was no discovery. There was just a motion for summary judgment, and it was granted. That he's entitled to discovery, and he's entitled to his day in court.
What discovery, counsel? I mean, we have the initial March 20th notification. We have the email from March 22nd. What other discovery?
The conversations between the parties. They had discussed the fact that they would use a credit basis from the Con Edison case as a set-off against the rental. Plus, he was arguing that he wasn't able to utilize the premises. That's an issue of fact, and that his entitlement to his day in court. I mean, it's premature to go ahead and grant summary judgment on a case like this. It's definitely he's entitled to both discovery and he's entitled to his day in court. Every court wants you to litigate the issues, not to do it on paper. They have a right to present it. Plus, he's a pro se. That's even more important here. They should have bent over backwards to give this guy his second chance.
You see, the microphone, helps increase the volume, so you don't have to shout.
I'm sorry, Your
That's
Honor.
why we use the microphone.
I'm a natural.
And so I know.
I can't help it.
I understand.
My
I
wife is
understand.
fighting with me every day. She
No,
says.
I understand. I'm loud as well, but the microphone is a wonderful invention.
I
Seriously,
apologize.
and it helps the vocal cords as well.
Okay. But it helps my point, too, if I raise it high enough. I don't know.
No, it doesn't. Trust me. Any other questions?
No, that's it. Unless you have a question.
I'm good, thank you.
Good afternoon, Your Honors, and if it pleases the court, my name is Richard T. Walsh. I'm with Horing, Gullicks, and Rosen DeGrugier, the attorneys for Lee Thai Enterprises USA. There was no lockout. In fact, there's an email from his client snarkily remarking on the fact that, well, you should have, it says, the right thing to do was to think things through before sending out an email that the building will be shut down. But let's assume counsel was right and there was a lockout. The problem with that argument is his client didn't comply with the terms in order to be granted a claim for breach of the covenant and quiet enjoyments. You have to not have defaulted under the lease, which is what was expressly conditioned here. So even if there had been a lockout, he has no claim for damages for that basis. But there was no lockout.
I just want to go back to that because your client did send an email, I believe it was March 23rd, 2020, indicating, right, that the building would be open with reduced hours and services. And I don't believe there was any denial of that receipt of the email. Am I correct about that?
No, my client did send an email and said, we think we may have to close it down because of the executive order. And then 2 days later, they say, you know, we don't have to anymore. We just realized as long as there's compliance with the COVID cleaning protocols, we don't have to close the building down. Therefore, we're not closing the building down. With regard to the electrical outage, there's no agreement. He points to an email from his client claiming there was an agreement as proof of the agreement. Well, that's not how it works. In order for there to be a waiver of the lease, has to be something signed by my client, something authored by my client saying, yes, there is an agreement. There was no such agreement. There was no issue of fact. They didn't prove there was an issue of fact. There was no eviction. There's no basis for claiming a partial eviction, a full eviction, a constructive eviction, never vacated the premises. In fact, the best proof we have that these premises were fit for the use of they were used is held over after the lease was over. And on that note, I thank Your Honors.
Thank you. Thank you both. Let's see, Zell Rezu.
Good afternoon, Your Honors. My name is Morton Alpert. I represent the appellant here. This is a threshold case under the no-fault law, and there are two burdens here, obviously. One, that the defendant has the initial burden, and it's our position that the defendant did not meet its burden at all to satisfy, by credible evidence, to show that the plaintiff did not sustain a serious injury. They used 3 doctors here, which is typical in this type of a case. They used an orthopedist who followed the dictates of the Toure case, Toure versus Avis Rent-A-Car, where, in essence, the court there held that there must be a comparative determination of the degree or qualitative nature of an injury based on the normal function of the body part. So this orthopedist, Dr. Regina Hilsman, she followed that dictate, and she did a complete examination of the basic injuries here, which are spinal. And
So, counsel, the accident occurred in 2013, is that correct?
the accident happened in 2013.
In 2013. And your client received treatment, right, for how long a period of time?
Well, for several months in the year 2014.
In 2014.
Yes.
And then there was no further treatment for 5 years?
2021.
5 or 7 years?
7 years.
Right. So we have that lapse in treatment, right?
Yeah, but Your Honor, before we get to that point, let's see if the defendant met its burden. And I say it did not meet its burden, and I'm going to give you the reasons. First of all, 6 times she relied on the American Medical Association guidelines to be the comparison.
Right, you said that they relied upon the 5th edition, and there was a 6th edition that should have been relied upon.
The 6th edition was published first in 2007, and the physical was in 2018. She should have been aware of that. And this is what the 6th edition says about the 5th edition. It puts it to bed. And I'm quoting now from the 6th edition, which is in the record. All attempts were made to correct the deficiencies in the 5th edition. Problems persisted. These were attributable in part to adherence to antiquated and confusing terminology, limited validity, lack of functional assessment tools, and lack of internal consistency. A high error rate among all ratings has been reported. How can that be a fair comparison when the American Medical Association almost completely revised, and I have the book here if the court would like to look through that book.
Was it included in your papers, in the record? Was it included in the record on the motion for
The
summary judgment?
quotations that I just read is in the record, yes.
So I did not quite understand your argument in terms of the 5th edition or the 6th edition. Was there anything in the record concerning the updated guidelines and how the expert relied upon or erroneously relied upon the 5th edition?
The defense did not rely upon anything in the 6th edition.
And there's a difference between the 6th and the 5th, which would cause some type of a different finding?
Absolutely.
And that was in the record? You included that in the
Yes.
record?
It's in the record. Let me ask you this, Judge, Your Honor. Page 150, 149 and 150 of the record concerns what's in the 6th edition. The print is very small, and it's also very light. And it might be difficult to read it. So I took it upon myself to, at my office, to try to enlarge the print so it'd be easier to read. And I have 5 copies here if the court should want it or be unable to read the tiny print that I copied from the 6th edition.
Thank you very much. You have time on rebuttal.
I don't hear you.
I'm sorry. You have time on rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. Jason Levine for the defendants' respondents. We submit that the motion court correctly rejected the plaintiff's argument regarding Dr. Hilsman's report and her alleged failure to use the 6th edition of the AMA guidelines as opposed to the 5th. Contrary to plaintiff's counsel's argument, there's no evidence here as to how these findings would have been any different if she used the 6th or the 5th edition. Dr. Hilsman set forth in her report her findings of the range of motion. She compared those findings to normal, all of which were normal, and set forth the manner in which she reached those findings using a handheld goniometer, which under hundreds and hundreds of cases from this court is sufficient to satisfy the defendant's burden on the serious injury threshold issue. And again, there's no evidence in this record other than plaintiff's counsel's argument regarding the significance of these, or what's the difference between the 5th edition and the 6th edition. The document that's submitted by the plaintiff in opposition, and as the motion court pointed out, it's unclear where this is from. She referred to it as a medical journal, but we really don't know what this is. It's unsworn. It's technically hearsay. There's no foundation, and there's no medical report to even explain what these sixth edition guidelines will be, or are, for that matter. Indeed, the affidavit and report of the plaintiff's chiropractor, Dr. Rubino, is completely silent and does not address at all this fifth and sixth edition distinction. In fact, Dr. Rubino, similar to Dr. Hilsman, set forth range of motion and findings just like she did, and there's no issue regarding the manner or what edition of the AMA guidelines was used. So we would submit, as the motion court found, that the submission of the reports of Drs. Hilsman, Golden, and Cohn satisfied defendant's initial burden, and therefore the burden shifted to the plaintiff to submit medical proof to raise an issue of fact, and that we would submit that the motion court again correctly determined that the plaintiff's medical proof, which solely consisted of the affidavit and report of Dr. Rubino, who only examined the plaintiff once, about a month after the accident, and then 7 years later, a re-examination in response to the defendant's motion. This doctor, there's no evidence that he treated the plaintiff any time in between those two visits. And there's no proof, and as the motion court pointed out, the plaintiff did not submit any of her medical records during those approximately 7 months of treatment that she received following the December 2013 accident. So we would submit that the court's conclusion that Dr. Rubino's affidavit and report and his findings and opinions therein regarding causation, significance, and permanency were speculative in view of this complete cessation of treatment, and I should point out an unexplained cessation of treatment a mere 7 months after the accident. Unless the court has any further questions, we'll rest on the argument in our brief.
Thank you very much.
Thank you.
I'm afraid we're skipping from the defendant's burden to the plaintiff's burden. As far as the neurologist, they had another doctor, a neurologist, examine her. And that's a joke. The neurologist, as part of her physical, the neurologist didn't examine her spine at all, period, but gave an opinion about it. And this doctor has a paragraph there called physical examination. Physical examination at page 67. And this is her physical examination. Quote, Ms. Zeal is a cooperative, well-nourished, right-handed, 35-year-old female who stands 4 feet 11 inches tall and weighs 120 pounds. She has blue eyes and brown hair. There is no bowel, bladder, incontinence, close quote.
This is Dr. Golden?
That's Dr. Golden, the neurologist.
So when did she also note that she diagnosed plaintiff with cervical, thoracic, lumbar spine sprain resolved?
Her conclusion was that there was a cervical sprain resolved.
Right, and concluded there was no objective evidence of neurologic disability or permanency. She also determined there were no objective neurological findings to substantiate plaintiff's subjective complaints. But she also noted that the reflexes were normal, demonstrated 5'5" power.
Well, that's the neurological examination. We're talking about the orthopedic injuries here. The orthopedic, the bill of particulars hardly claims any neurological injuries. They're orthopedic. They're the spinal injuries, cervical, thoracic, and lumbar spine. And she never even indicates in her report whether she examined the spine at all.
Thank you. Thank you both. Tate versus Rhyme Plumbing.
It's still afternoon. Good afternoon.
Of course it's still afternoon. What are you trying to suggest? 4:15.
You've been moving along very swiftly. My name is Evie Kazansky. I'm appellate counsel to the law office of Thomas Moore for the defendants. The procedural posture of this motion was the defendant's motion for summary judgment. As a contractor, none of the exceptions to SB are now applied, that the basis of their work was approximately 3 months prior to the alleged accident. The work.
So this is Ream, right?
Yes.
Ream. So, but your client did work in the corridor, is that correct?
Yes, Your Honor.
And so can we, on a motion for summary judgment, make a determination based upon the record presented that whatever work was done in the corridor had no correlation to the leak in the storeroom?
Yes, Your Honor. I think on this record here, we're a typical contractor, and it's not the proximity. It has to be in and around the area. It's clear that the work being done through the August 4th, 2017 invoice, which is the only invoice that's really at issue
Which is
in the
for
order.
work in July, right?
The work was July 14th and July 18th in the corridor on a waste line. The accident occurred where the plaintiff is constantly working, in a storeroom, on what they consider a water line, and that is based on his own testimony that the water was clean and there was no issues with the water. The biggest issue here in favor of also the defendant is that the plaintiff himself works in that area and in the storeroom, not the corridor, and has been in that storeroom every day, and he was there the day before.
He testifies that he's not aware of any repair having been done in the storeroom.
He's not aware of any repairs. There's no comprehensive duty. This is an on-call kind of contractor, despite what the plaintiff argued.
There's also evidence in the record, is there not, a testimony at your client's EBT, that all the pipes are in bad shape, and all the pipes in that New York Presbyterian basement could have used replacement.
I think it's evident from just the few invoices put into the record that everything that Ream was doing was on an emergency call basis. But in particular, with respect to this situation, it's typical of a contractor doing
Am I recalling correctly? He specifically testifies that the pipes are in bad condition in that basement.
Yes, New York Presbyterian had the ultimate duty and was not replacing. Even the plaintiff himself said that a lot of the pipes needed replacement, and New York Presbyterian was basically doing it on an ad hoc basis. So he did not even understand why that. He wasn't even sure the pipe was leaking until the morning he came in and saw a bucket overloading. But when he left the night before, there was no water in that storeroom, which was nowhere near the corridor area where we did the work 3 months before. Thank you.
Thank you.
Good afternoon. If it may please the court, Matthew Duco for the plaintiff respondent. We've filed our briefs in regard to this, and certainly we believe that there's an issue of fact as to whether the plumbing service of Ream Plumbing created or exacerbated the issue with the basement water piping at Presbyterian Memorial Hospital.
So what is the significance of the fact that the pipe that Ream was working on was was the waste line, and the pipes in the storeroom where the plaintiff slipped, was a water line? How do we make a correlation between the two?
Right, and I don't think there's a significant difference there, and there's certainly nothing in the evidence showing any difference between those two pipings. And in fact, when the agent the employee that was produced by defendant Ream Plumbing was asked about their work in the basement, he wasn't able to even articulate exactly where in the basement they were doing the work or how far from where the plaintiff was injured that work would have been. He testified he did not know. When asked, and this is on page 260, 261 of the record, when asked specifically how far it was, he says, I don't recall 100%. He even says, I'm not sure what building this would have been in.
Didn't he also testify that it's in the corridor around the corner from the storeroom?
Well, he testified that I believe this would have been on the opposite end of the corridor, maybe. I don't recall 100%. That was his testimony.
But
he had no idea where in the corridor
he hadn't done the work in the storeroom.
Yes, Your Honor, that's correct. However, obviously, the corridor is right outside the storeroom.
The storeroom is a very large room, is it not? It had 14 aisles, didn't it?
Correct? It's a large basement. And defendant was not able to identify where in the basement they were doing the plumbing work just prior to this leak occurring.
But it was not in the storeroom. That we know for a fact.
Well, I'll say this, as far as their testimony and the evidence that's in the record, they stated that the invoice was for work in the corridor.
In the corridor?
Correct.
Not in the storeroom?
Correct.
And an invoice was a business record generated in the ordinary course of that business, and it was contemporaneous when made at that time.
Correct. And when asked how far from the storeroom that work was done, obviously the corridor leads to the storeroom. There's going to be a wall there with the pipes leading from the corridor into the storeroom. When asked how far from the storeroom the work previously done was, the defendant's witness was not able to say. When asked whether the work in the corridor could affect the piping in the storeroom, he was not able to answer. The witness they provided was in fact not even a licensed plumber who could have provided any type of evidence as to that issue. Thank you.
Do you have a question, Justice Shulman?
No. Okay.
Thank you.
This is a typical case where the flip side is when we go to trial, the plaintiff now has to prove that the work that we did was a proximate cause of the accident. It's clear, as Justice Friedman is saying, and Justice Mendez, that the work was done in the corridor. It's now going to be speculation and innuendo that the work on the 8-inch galvanized steel pipe in the corridor is somehow intricately related to a water line in the storeroom. So now Ream has to defend a negative and speculation and innuendo, and that's not what a material issue of fact is. A material issue of fact is a fact that's questionable to a jury. Just by saying, well, maybe they did work here, and maybe they did work here, it's a typical contractor case where we worked in the proximity of the location, but this court has continually said...
They had these rotating plumbing contractors coming in. They had their own staff. New York Presbyterian had their own staff of people to do plumbing repairs. Isn't that so?
Yes.
And they supplemented that with a rotating group of contractors who would come in from time to make repairs, plumbing repairs in the basement and other places in the building too, undoubtedly. And there are all sorts of repairs going on all the time.
Yes, and we would submit that we'll be back here after a trial suggesting that it was all based on speculation and innuendo.
I just have a question. Can you just respond to counsel's statement that the witness was unable to testify with respect to what, if any, effect that the pipe where the work was done, would affect other pipes? Can you address that?
That's how he testified, but he was also clear that based on what he knew of the testimony of the plaintiff, that the two pipes were independent systems from each other. So that one was a waistline, and if the work that they had done based on the invoices starting on page 310 of the record, the plaintiff would have walked through sewage and felt sewage as opposed to just feeling water upon himself. Thank you.
Thank you. Thank you both. Burlington versus New York Construction.
Good afternoon, Your Honor. My name is Anna Manalese from Adrian and Associates, respectfully appearing for appellant, the Burlington Insurance Company. May it please the court. Your Honor, this is an insurance coverage case that has its roots in an underlying property damages case alleging approximately $4.8 million in damages. Century filed a pre-discovery motion to dismiss, arguing it should be let out of this case because its policy was excess to both Burlington policies, and the lower court agreed with Century. The lower court was wrong for two reasons. The first reason is that it was premature for the lower court to determine to let Century out. Because to begin with, we don't even...
This was Burlington's lawsuit, your lawsuit for declaratory judgment.
Yes.
Originally, you sought relief both as to your 2013, 2014 policy and your 2014 to 2015 policy. You're no longer seeking relief, correct me if I'm wrong, to 2014 to 15 policy.
Yes, Your Honor, that's correct.
You can see that that policy has exposure in this case.
Yes, Your Honor. Our only argument, in this case is that the Century policy goes after the 1213 policy. After Burlington's earlier policy, the Century policy goes next, and then the later Burlington policy. That is the order we are advocating for. Now, the lower court...
Is that tied up with an ultimate factual determination as to when this property damage, this damage caused during construction to a party wall and related items, when that occurred?
Yes, Your Honor, and that's my point, is that the lower court should not have resolved this exhaustion issue until it is determined, until the trigger of the property damage is determined. Because all we know, Your Honor, from the underlying complaint is that the work was done in 2012 and the damages manifested itself in 2014. But we don't know what these damages are, and the underlying action is still in the discovery stage. Therefore, it was premature of the court to resolve the issue of allocation or exhaustion, because exhaustion or allocation is an issue to be resolved only when you already know the damage, what the damages are. And in the Viking Pump case that the lower court cites to, the reason why the court resolved the exhaustion allocation issue was because Viking Pump involved a long-tail claim. They already knew that there was a long-tail claim. We're not here yet. We do not know what the property damages are. We do not know what the coverage trigger is. Therefore, it was premature to let Century out now. The second reason why the lower court erred is the lower court misapplied Viking Pump, because the lower court jumbled the exhaustion test with the allocation test. Viking Pump involved two issues, exhaustion and allocation. The lower court used the allocation test to determine exhaustion. Specifically, the lower court said that because
Does resort to long-tail precedents make sense in this case? This is, after all, not a long-tail type of situation. This is not a case of environmental damage over many, many years and maybe decades. This is a rather discrete, limited period of time, isn't it?
Yes, Your Honor. This is a construction defect case, and right now, we do not know yet whether damages will be able to be pinpointed, for example, to the 2012-2013 period, or whether this is a continuing thing. Like I said, Your Honor, all we know is that the work was done in 2012, and the owner started noticing crumbling walls in 2014. So discovery is still ongoing in the underlying action. Therefore, it was premature for the court to resolve this issue. Now, going back to the court, jumbling up tests and using a test meant for allocation to determine exhaustion. Now, that's just wrong. The court said, because the policies do not contain any non-cumulation or prior insurance provisions, then horizontal exhaustion must apply. This was a jumbling of tests because the presence or absence of non-cumulation provisions is determinative of the allocation issue and not the exhaustion issue. And it looks like I'm running out of time, so I will address any questions on rebuttal.
Thank you so much.
Thank you.
Your Honors, this is Craig Rockison for the respondent. In the underlying decision, the court did use the term horizontal exhaustion instead of pro rata allocation.
Did Supreme Court hold in your favor because of a failure to include a non-cumulation clause in the policy?
That in the underlying Burlington policies and in the policies that were issued by.
And what does that mean here? How does that get applied over here?
In this situation?
Yeah.
It essentially means that the insurance doesn't go, the insurance needs to be allocated by the actual time on the risk for these damages. With respect to whether this is a long tail claim, we're talking about a construction defect that occurred in 2012, was discovered in 2013, and it has been litigated for.
It means that you don't have to limit ongoing losses to a single policy period, right?
That's correct.
I mean, that was Supreme Court's outlook on this.
Yes, and in this construction defect case, that appears to be the case to Century, which is that there is ongoing property damage to a party wall.
But your Century policy, doesn't it explicitly say that the underlying policy to which it's excess is the 2013-2014 Burlington policy?
Yeah, which again limits damage to, limits insurance to damage that occurred during that policy period. Therefore, an all sums allocation is
So once that 2013-2014 policy is exhausted, why under that provision wouldn't Century become liable?
To the extent that would become exhausted before any of the other policies, I agree with my adversary. But that doesn't appear to be the case here, because we're talking about an ongoing construction defect case, and the Viking pump case stands for the proposition that when there is ongoing damage, that there should be a time on the risk formula.
So is this really an ongoing type of risk type of case in its traditional sense, because it's not in the nature of an environmental damage which goes on over many years? I mean,
it's not asbestos. I understand all of that.
Construction job and.
But we are talking about a situation where there are multiple policies that are being triggered by these ongoing damages.
As I understand it, there's only one other arguable policy, the Everest policy. Am I right?
I believe
you have Burlington as the primary.
Mm-hmm.
And Everest is in the loop somehow for an earlier period, 2012.
Yeah.
And they're providing a defense, bear with me.
Of course.
And then we have Century, which is the excess, and nobody's really disputing now that Century is the excess solely for the 2013-2014 primary policy period, correct?
Yes.
As we sit here now, we have no idea whether 35 Crosby Street damage, if I got the address right, was the damage and the scope and breadth of it, as you both mentioned, construction defect, is limited to the 2013-2014 period or 2014-2015 period. But we can all agree that if in the 2013-2014 period, based on vertical exhaustion, first you exhaust your primary Burlington, and then, as counsel pointed out, at $4.8 million, if that's proven, the excess would come in. Do you agree with that?
I agree to the extent that all damages are allocated to a specific policy, but that doesn't appear to be the case here. To a specific policy period. But that doesn't appear to be the case here. It appears to be a situation with ongoing property damage such that a pro rata time on risk allocation would be the correct allocation.
So didn't Supreme Court err in deciding in favor of Century, because you couldn't possibly decide in favor of Century until you know when the property damage occurred? You cannot make a determination on this until you make a determination of when this happened.
And our position is that based on an ongoing property damage case, that the time on the risk formula would mandate that all of the primary buckets, if you will, of insurance should fill before the implication of any excess policy.
Sir, Aspen is the subrogee here.
I believe that to be the case.
The property, the insurance, 35 Crosby has property damage insurance. Aspen has its own action as a subrogee to try and take money.
I believe, and Everest is another, yeah.
My point
yes,
is,
yeah, Aspen is subrogee.
if I have property damage, you see, I didn't see anything on this record that determined right now, there's nothing on this record that determines this is a long tail case like the asbestos cases or some of the other cases that Viking Pump was talking about, or the environmental type cases. We have a party wall that may be compromised, some other damage that the work on 37 did to it, which if I were the property owner of 35, I would immediately start trying to repair. Like yesterday, party wall's a big deal. So, and that means insurance went to pay for it. That's why they started their subrogation action, correct?
Correct.
So for all intents and purposes, there's nothing that's ongoing. We have to determine exactly when it happened and where it happened and the scope of it. And we don't know that now, correct?
That's correct.
Which makes counsel's point that dismissal is premature.
I believe that the Supreme Court was correct in its determination.
I mean, based upon what Supreme Court did, the way things stand now, they dismissed the case against Century, right?
Yes, they did. The genesis of this case was, and I don't
basically,
want to take
Century-
on most of,
I'm sorry, as things now stand, Century can just walk away.
that, I don't believe that to be the case. It's just how the policies would be exhausted underneath Century, not that Century can just walk away. The primary policies would have to be exhausted, and then once that happens, Century would then step in to the extent that there's damages that would reach its layer.
Thank you, counsel.
Thank you.
Your Honor,
You'd have to bring a new lawsuit for things to happen the way counsel said, right?
Yes, Your Honor.
Century, in the face of this decision, is not volunteering to pay.
Yes. Your Honor, just to summarize, as you pointed out, the exhaustion allocation issue is premature because we do not know yet if there is a long tail claim. The court does not issue advisory opinions. At this point, it would be an advisory opinion. And the lower court erred for misapplying Viking Pump for using the allocation test to determine the exhaustion issue. I have nothing further, Your Honor.
Thank you. Thank you both.
Thank you.